Good to go, Brian?
Yeah, I think it would be good to wait a brief moment so that Commissioner Carrion can join. I will also text her. Okay. There's Steve. So my email was received.
I wanted to go ahead and gavel us in, and then
Okay.
assuming she joins us. So convening the May meeting of the California Law Revision Commission, I will gavel us into session. We appear to have a quorum. Is that correct, Mr. Executive Director?
Yes.
Then let me call for the commission's first item of business, and I will hand the gavel over to the Vice Chair, Ambassador Huebner.
Thank you, Chair. Thank you for joining us. The meeting has come to order. For the public record, the commission met briefly in private session prior to this open session. Two items of business were handled. The commission voted to approve the appointment as Chief Deputy Director of Kristen Burford. And number two, the commissioners discussed the applications received for the position of Executive Director. The commission made the decision to interview 6 of the candidates and has identified those 6 and will notify them of their selection and will then schedule interviews. No other business was conducted during the executive session. Brian, would you like to wait for Commissioner Carrion to join us, or shall we proceed?
I think we could proceed. She's going to need to make a statement when she joins about recusal from the closed session, but she can just interrupt the flow if necessary. And Kristen, because she was tardy, didn't hear the news that the commission approved your appointment as Chief Deputy Director. So we will be.
Congratulations, Kristen.
Congratulations.
Thank you. I look forward to working with the commission in my new role.
Yep. Okay, so I think we can just go ahead, and when Commissioner Carrion joins us, she can make her statement, and then we can continue on.
Very good. The next agenda item, minutes of the last meeting. Does any commissioner have a correction or addition to make? Hearing none, is there a motion to approve?
So moved.
Is there a second? Yes, Commissioner Jenkins. Brian, do we need to call the roll on the minutes?
Yes, I'll do so now. Alphabetically, Carrillo has left the meeting, and I want to make a point for my staff that he was in attendance in the closed session and briefly in the open session, but has gone to bed. He's in Japan, and it's like 2 a.m. there. So he's dropped off the meeting. So the minutes need to reflect his absence for all decisions that are made subsequently. So, and so she's not here yet. Cubas.
Yes.
Huebner.
Aye.
Jenkins.
Aye.
King.
Aye.
Commissioner McAllister is absent today. Simpson.
Aye.
Okay, that's approved.
Excellent. Thank you all. Next agenda item, report of the executive director.
Thank you. Just in general, I wanted to say that I'm going to be pretty much booked up with admin items for the next interval. I'm not going to be producing much new study material because my approaching retirement has lots of work that needs to be done for a successful transition. So that's going to be my emphasis. There is one other point that's worth noting, which is We were contacted by somebody who is following our study of the toxic materials recodification, who requires an American Sign Language translator. And we are going to provide that service, but we've never done it before, and we have to figure out how. Just doing it would be relatively simple, and that's actually one of the benefits of Zoom, is that I understand that there are translators who will join a Zoom meeting for translation purposes for the duration of the discussion that for which translation is required, and then drop off. So you might have to only hire somebody for an hour, as opposed to an entire day, plus maybe travel costs, etc., if we were meeting in person. But in any event, the complication is the state contracting requirements. And so we have to figure out how to comply with state law and established guidance on who we can contract with for that service. So because of that, I postponed any consideration of the toxics topic at this meeting. We will return to it hopefully in June, and I hope we will have sorted this issue out. If we still haven't, then it might be that toxics gets bumped again to the next meeting after that. Another benefit of Zoom is that we put our meeting recordings up on YouTube, and that's at no cost to the commission. And it creates a basis for a permanent archive for those. And the other thing is, if we break the discussion up into chunks of 2 hours or less, YouTube has a closed captioning service that they provide automatically. And I have found it to be pretty good. That's part of, we do it in part because the Rehabilitation Act requires that governmental audiovisual contact have closed captioning. But the person who made the request for the ASL translation said that that is not an adequate substitute, in part because it's not reliable enough. And we do have a lot of technical discussion, so it wouldn't surprise me if it misses occasionally. But the other thing is that if we want people with hearing disabilities to be full participants and have the ability not only to hear in real time rather than after the fact and be heard if they want to comment, then that requires translation at the time of the meeting. So we're happy to accommodate that, and it's just a matter of figuring it out. I don't expect it to be impossible. I expect we'll figure it out, and that we'll have that service up in June. The other aspect of that is that we will probably need to set a time certain for the toxics discussion to give greater predictability to the translator so that they can come in just when they're needed and then depart when we're done with that topic. And that's all I have to report.
Thank you. Would you cover as well the other two administrative matters?
I see that Kristen's raising her hand.
Yeah, there's
Oh,
actually just
Kristen?
one thing I wanted to mention for the commissioners to let everyone know. Grace Wiley, our extern this term, she received an award for Outstanding Externship Student. So I just wanted to share that award, that she received that with the commission. That was from the Clinical Legal Education Association, and she was selected for UC Davis. So
Wow.
Just a point of information for everybody. I know her work got compliments from commissioners, and I believe that was actually acknowledged in the award. So.
Excellent. Commissioner Simpson?
And with respect to Grace, I learned after her meeting with us, she's the daughter of a longtime friend of mine, George Wiley, who I worked with through multiple speaker offices. So kind of, small world.
Absolutely.
So I will note
Kristen, please.
I'll
Kristen,
note that
please. give her-
award in the minutes. Sorry to interrupt.
Oh, no, I was going to say, Kristen, please give her the commissioners' congratulations.
Absolutely. I will pass those along.
Thank you. Brian?
Yeah, the next item up is a memorandum 2324, which is the draft of the information request response to Senator Laird's office regarding our experience with telecommunication. Teleconferencing in conducting our meetings during the COVID pandemic. So the commission asked to see the draft before I send it. And so I would just ask whether anyone has any suggestions or concerns.
Are there any? It was very well written. Thank you for that effort. Hearing no objection, it's fine to send it, Brian.
Okay, I will actually call the roll because the teleconferencing law requires a roll call vote.
Thank
So,
you.
yeah, I try hard to remember that, especially when it's an item where it's clear that there's unanimous consent, but I will continue. Carrillo is not here. Commissioner Carrion is not yet here. Commissioner Cubas,
Aye.
Commissioner Hebner,
Aye.
Commissioner Jenkins,
Aye.
Commissioner King,
Aye.
Commissioner Simpson.
Hi.
Okay, that's approved. Thank you. The other admin item that remains is the legislative program memo. That's memorandum 2325. And it's mostly just a report. The legislative program continues to proceed without significant problems. The only point of decision has to do with AB 522 CALRA, which is the bill on notice to customers of communication service providers when an administrative subpoena is used to obtain their communication records from the service provider. So you can't just serve a subpoena on the service provider, hey, AT&T, give me this person's email content, without the person whose content is being requested also receiving notice so that they can object. No, there hasn't been any objection or opposition to any aspect of the bill, but the ACLU Northern California weighed in with some suggestions for improving clarity where they thought clarity would be helpful. And one of those suggestions I'm not going to discuss here because it's still being considered by the author's office. And there's, while those discussions are continuing, it wouldn't be proper for me to disclose anything publicly about it. The other concern was ACLU wanted greater clarity about the purpose of the proposal. And they had suggested some statutory language, which I thought was not really necessary, because I think the proposal is so narrow and clear that its purpose is kind of obvious. And when you start to add language that paraphrases law into a statute, you are opening the door to that language being argued as an interpretive gloss that people can say, well, obviously it means something other than the plain language suggests, because they went on to say, and then they argue that for some other meaning. So I'm leery generally about paraphrasing it in statutes, but there's less risk of that in the commission comments. And in fact, in the past, we've used commission comments, offered them as an alternative to statutory clarification. They still have effect because courts consider them evidence of legislative intent, but they aren't the law itself. I'm still not entirely convinced that clarification is necessary because this proposal is, like I said, so narrow and focused. And courts also look to our reports generally. It's a little harder to find them than the comments because the legal publishers produce our comments in their annotated codes. But courts will accord the same dignity, interpretive weight to our report's narrative as it does the comments. So 6 of one, half dozen of another. I don't feel strongly that it would be a problem or that it's really needed, but I offered to suggest some language. And you can decide whether or not you want to have it included in the recommendation. The recommendation has not yet been put into final form, so it would be easy for us to just revise our comment before it is put into final form. But the language that I'm describing is starts at the bottom of page 2, continues on to page 3 of the memo. And I would say I drafted it to emphasize the constitutional rationale for the reform. The requirement of the reform is clear, and our report makes clear why we're proposing it. But the section itself does not say the same thing. It doesn't say that there is a constitutional dimension to the issue. And so that's what I meant to emphasize in this language. And I'll read it. I'll skip over some citations, but I'll read it. This section requires that a customer of a communication service provider be given notice and an opportunity to object when an administrative subpoena is used to seek the customer's electronic communication information. A failure to provide such notice before the customer's electronic communication information is provided pursuant to the administrative subpoena is likely a violation of the Fourth Amendment of the United States Constitution, Section 13 of Article 1 of the California Constitution. And then there's some cites, which I'm going to skip. They're just reiteration of citations offered in the body of our recommendation. So the question before you is whether that language causes you any concern, whether you think having that in the record might lead to some problematic result, or if you just think the general risk of such a result is high enough to leave the language out, or if you think it would be helpful if the annotated codes make clear that what we're trying to do with this language is avoid a constitutional problem.
Are there any questions or comments from commissioners? Commissioner Simpson?
I'm actually not sure we ought to, I mean, the first sentence of that seems fine because it's describing what it does. The second sentence is drawing a conclusion about, what the implication is if that kind of notice isn't provided. I'm not sure that we ought to be making that kind of conclusion. I mean, it seems to me we ought to stick with what it is we're doing and not necessarily coming up with a conclusion about what failing to do that implies. That's up to a court or whatever, it seems to me. So I'm not sure what problem this additional language solves.
Other comments or reactions? Commissioner King?
Yeah, I agree with that. What made the decision for me is the word likely.
Yeah.
When do people make comments saying it's likely this?
Well, there's no case directly on point.
Right. I understood the spirit, but
Yeah.
but it still inherently shows the weakness of the proposition.
Yeah, I agree as well with Commissioner Simpson on this.
And I will add, just to sort of maintain institutional memory, since I'm going to be departing the stage soon, we have in the past had gotten pushback from committees when they said we were legislating by comment. They were saying, if you need your rule to be clear, make it clear in the statute.
Yeah.
Okay, so my sense is I'm not seeing any support for including this comment language. Is that correct?
I agree.
That looks like that's it, which
I'm
means
gonna
you
call-
don't, which
Go
means you
ahead.
don't need a vote from us.
Do we vote to
Brian,
not?
you don't-
Yeah, sure. I'll say in the minutes, the commission did not approve the proposed comment language. And I don't think I need an affirmative vote for inaction.
Okay, good.
So that concludes the admin stuff. A reminder that we're going to have our expert presenter on antitrust coming in at 11. So I think it probably makes sense to jump straight to the ERA topic and see how much of that we can get done before 11, and leave off the trial court restructuring item for later. It's not
Yes.
urgent.
Well, so that I agree. So that commissioners, though, can be fully focused when we start at 11. We should leave, we should schedule a short break just before 11. How
Alright.
much of the ERA do you think we can get done in the next 20 minutes or so?
So
Brian.
the
Or
memo
Kristen?
well, the memo is mostly informational. I mean, so I do think at some point I can talk as much as the commission wants to hear. You know, we can walk through, there's a lot of law in there, but I don't know that we need to sort of march through all of that. If the commission has any other directions or things they'd like me to explore, that would be helpful to know, but we could just kind of start with the presentation and see. It might be that we don't need to get into the details very much. That will depend on, you know, what the commission wants to discuss.
Okay, sounds good. Why don't you proceed? Thank you, Kristen.
So today before the commission is memo 2023-26 and the first supplement. I'll just note the first supplement was released. We discovered a few potentially confusing errors that we wanted to make sure the record corrected. And so aside from that, I won't be talking about that first supplement. In general, this memo was a challenge to write, I guess, is where I'll start. It touches on some very difficult questions about how to balance competing interests. And those questions have not been answered. I think one of the challenging things legally about writing this memo is it's hard to touch ground. There are some very active areas of litigation, and the court seems to be questioning some of the longstanding precedents in the areas that are at issue here. In short, what I was trying to do in this memo is give a sense of when First Amendment protections in the federal Constitution might be in conflict with efforts to achieve sex equality. And of course, sex equality, as we're thinking about it for the commission's purposes, you know, includes issues of sex stereotypes, pregnancy, sexual orientation, gender identity. So overall, there were kind of two main things that I wanted to do. One of the things is sort of thinking specifically about religious objections, because that's an area where there is a lot of movement with respect to the Religious Freedom Restoration Act and the Affordable Care Act, whether you need to provide reproductive healthcare services or insurance, gender affirming healthcare and insurance. So that area, trying to get a sense of what the court's view on religion generally is, and, you know, as best we can, try to see where the court's moving in that direction. Of course, that's a challenging thing to do. So we just tried to identify the state of the law, the things that are out there that have gotten to the level of the Supreme Court. The other thing that I did was try to focus on the specific areas where we saw First Amendment case law that sort of directly related to sex equality issues. And those were not necessarily related to religion. But I guess where I'll start is, you know, the memo covers, I think, four main things: the Establishment Clause, and that's covered primarily just to give a sense of the direction that the commission, or not the commission, the court has been moving on treatment of religious matters generally. The Free Exercise Clause, and in part that's because there is a longstanding precedent in that area, that's the Smith case, about how to assess whether or not a generally applicable law violates the free exercise protection. That has been called into question, I think, by a majority of the members of the court speaking in their concurring opinions. Now, what direction that might go is uncertain, but one possibility is sort of the direction that that Congress took in the Religious Freedom Restoration Act, which they enacted in response to the Smith case and trying to apply a compelling interest test to free exercise cases generally. So that, I don't know if the commission would like to hear more about those details and sort of the direction of that case law. I will say, you know, one of the interesting things about looking at the free exercise cases was there seemed to be a dramatic difference, or at least the world perceived there was a dramatic difference when the Smith case essentially said, you know, generally applicable laws that don't target religion, that aren't, you know, driven to focus on religious conduct, they don't violate the free exercise clause. That seemed to, people felt like that was groundbreaking as far as I could tell, but overall, the scholarship was sort of suggesting that the dramatic change that was being described was not really seen in the legal outcomes preceding Smith. And in fact, the strict scrutiny test, which you would assume a lot of things would be overturned, you were seeing more generally applicable laws actually being upheld, that they would find that that test was satisfied. So while there was sort of a dramatic difference in how the court talked about the test that they were applying, the overall outcomes in the cases weren't all that different. Now, certainly you can see that some of the justices in a more recent opinion have expressed some dissatisfaction with the Smith case, and they want, I think, religious claims to have a higher level of scrutiny under the free exercise clause, but it's hard to tell what direction that might take at this point. So I guess I don't know if there's any questions from the commissioners on the free exercise jurisprudence or that piece of the memo. Commissioner Huebner.
I have just one question, which is, in any of the cases, if you reviewed, have courts addressed what may be the foundational question of what constitutes a religion and what constitutes an authentic religious belief, as opposed to something laundered through religion?
So I don't know that they've addressed that directly. My general sense from the cases that I've looked at is the court takes a very hands-off approach, and that it's hard to, courts are disinclined, I think, to question the sincerity of a religious belief. And it does not need to be connected, I think, to a specific organized religion, as far as I could tell. And it can be a very personal religious belief. It does not have to be something that is necessarily, you know, some of the cases suggest that the people are not sort of actively participating in organized religion. So I don't think that that's a qualification, but that's just sort of me drawing from, you know, having looked at a number of cases. I have not seen courts scrutinize the validity of those religious beliefs very often. The one exception that I will note is the memo discusses some race discrimination cases where there were religious objections to abiding by race discrimination prohibitions, and those were not viewed as valid religious objections.
Why though? For our purposes, the why is very important on this one.
So it was not entirely clear, unfortunately. One of those, it was a footnote that just was very dismissive and brief. And the other case, the Bob Jones University case, the court did acknowledge that there was a compelling interest in eradicating race discrimination, and therefore that compelling interest, I think, was allowed some restriction on religious beliefs that might come into conflict with that. And there is some indication where in later cases, the freedom of association cases, where there is a compelling interest, the courts are willing to accept some limitations on the First Amendment rights.
Just a final question, which is again definitional about compelling. Is there a standard articulated, or is compelling simply a synonym for we've decided not to be bigots on this one issue, but we'd like to remain bigots on the other issues?
I haven't seen any specific, I mean, compelling seems to be kind of a legal term of art, and that's often used in the strict scrutiny context. It's not clear to me when the court might decide that, you know, the state interest is compelling or not, and how they would make that determination. I haven't focused specifically on looking at that, but I honestly can't really draw from much to say generally how you determine like whether or not you've reached that threshold. That's a difficult question, I think.
Brian?
Yeah, Kristen, correct me if I'm wrong, but my understanding is that the case, and I'm not going to remember the name, but the wedding cake bakery case out of Colorado, the court actually found that at the hearings conducted by the state of Colorado's Human Rights Commission, they found that questioning the sincerity of the religious belief at issue was unacceptable animus against the religion. Is that fair, Kristen?
Well, I mean, I think I might shade that a little bit, which is I think that they suggested that some of the comments that were made about what religion had been like, I think there was a suggestion that religion was used to justify the Holocaust or something. And I'm not going to get that exact. Yeah. So those sorts of ideas, the fact that those were expressed in that commission's process, the court was concerned that they were not being even-handed and religiously neutral as they were required to be. So,
and my point is just that I think the current court is going to be pretty skeptical of anyone who tries to say that religious beliefs aren't sincere.
Well, and that's why my predicate question was, do they define what is an acceptable religion? And it sounds like there is no answer to that it's a fluid concept, not limited to an organized belief system.
well, and like I said, I haven't seen any cases that directly address that, but having looked at the facts of a number of cases, my sense is some of the cases involve plaintiffs or defendants, I'm not sure what their status is exactly, but the cases involve people who are not involved in organized religion and have been the beliefs, so I think, are more personal, and they may be tied to a certain belief system, but I don't know that that's necessary, I guess, is just not clear.
And I might add that back when I was doing unincorporated associations work, I looked at some of the issues surrounding religious organizations and found case law, this was many years ago, but found case law where the courts expressed an inability to adjudicate questions that were fundamentally doctrinal within the religion itself. So I think they felt that the free exercise clause precluded them from acting to evaluate the religious argument's merits in some circumstances. And these cases I was looking at were cases where there'd been a schism within a church and they were arguing about who gets the property. And the court was saying, this is fundamentally doctrinal. The state is not going to determine who is the legitimate Methodist church in this community, etc. We just got joined by Aushra Deluard, who's going to be making our presentation on antitrust. We're talking about another topic now, after which we're going to take a brief break and then come back to you. So probably right around 11 if we can manage it, but I'll stop interrupting, which will probably help.
You're not interrupting. Are there questions or comments from other commissioners on Kristen's report thus far? Hearing none. Kristen, do you have another couple of minutes before we take our brief break?
Yeah, so I think I might actually jump to the free association piece, which is the end of the memo. That one I think is a bit easier to cover. There were two cases in the 1980s where the court considered associations who were excluding women and whether or not they needed to abide by anti-discrimination protections and include women. And the court in those cases found that there was not a strong enough associational interest to exclude women, and found, and I believe the word compelling came up in one of those cases, that there was a compelling interest in addressing discrimination against women. Later, the court kind of limited that doctrine a bit in terms of association and indicated that there might be reasons why an association could act against anti-discrimination protections where there's a specific expressive interest. And then in the context of sexual orientation, the court found those expressive interests existed. One of those cases was the Boston Evacuation Day, St. Patrick's Day parade, and excluding a group, their acronym is GLIB, the Gay, Lesbian, and Bisexual Irish Americans, I believe, from that parade. And that was in part because of an associational message, and the court concluded that the parade organizers' expressive rights did not require them to include any sort of message that they didn't want to include. And then in 2000, the Boy Scouts case, where the Boy Scouts were found to have an interest in excluding an assistant scoutmaster who was homosexual. So in that case, the court concluded that the associational expressive interests actually did, run counter to, and in those cases overrode the anti-discrimination protections as they would apply to those groups. So
Now, Kristen, we don't want to rush you, so we can pick this up again after we hear from our professor, if that's okay.
yeah, so I was going to suggest we do that because I think the free speech claims might be a bit more complicated and they may require more conversation. I just want to acknowledge, like, the free association, those cases are a bit older and there hasn't been as much movement in that area lately. But the compelled speech, I think, is the one remaining issue that we have not yet covered, and we can pick that up afterwards. So I'm happy to take any other questions from the commissioners on the free exercise or free association cases.
Are there any questions or comments at this point? If something comes to you, we'll pose them after we finish with our guest speaker.
That sounds
Thank you,
great.
Kristen.
Thank you.
Let's take a short break and be back right on the hour, if that's okay with everyone. Very good.